paso la paraula al senyor Didri.
Good morning, and thank you very much for this invitation. It's a great honor to be able to come and to provide ECRA's view on this important issue. For those of you who are not aware of ECRA, we're the European Council on Refugees and Exiles. We were created almost 40 years ago, and we comprise refugee assisting organizations, 81 NGOs across almost 40 European countries. The right to asylum based upon sexual orientation and gender identity is a topic that is gaining currency and attention because we and our members feel it's an important component of the broader challenges faced by refugees seeking protection in Europe. And let me make one thing clear, because I think from some of the questions that you were asking, there may be at this point a bit of a misconception in the room. There is, as Jean Lambert had mentioned, there is now legislation in place. There is a common European asylum system based upon legislation. So the policy is there. The problem and the challenge is in the practice. And as she mentioned as well, it's not yet a common system. And in fact, it's very far from a common system. But we are now at least beginning to work on a common legislative basis and moving forward from that. Now, we understand that LGBTI asylum seekers face particular and additional challenges which must be addressed and responded to in order to create a more humane common European asylum system. And moreover, the numbers of asylum applications based on sexual orientation and gender identity in the European Union is significant, and as the Spanish experience shows as well. So ECRA participated in the groundbreaking Fleeing Homophobia study in 2011 as a member of the project's advisory panel. And this remarkable project was carried out by COC Netherlands, our colleagues on the other end of the table, and the Free University of Amsterdam. It shed light on the situation of LGBTI asylum seekers in Europe and the processing of their claims. So what are some of the current challenges? Well, less than 2 weeks ago, the Court of Justice of the European Union delivered a much expected judgment that has shed some light on the questions surrounding asylum claims based on sexual orientation and gender identity. As stated succinctly by The Economist in an article entitled "Bigotry by Degrees" in its recent November 16th edition, The Economist said, "European countries want to limit immigration. The court therefore made a distinction between those who have it bad and those who have it worse." So as we can see, the timeliness of this discussion is particularly relevant. So in my presentation, what I'd like to do is, one, address some of the most acute problems that have been found in the processing of applications from LGBTI asylum seekers. Two, examine what solutions are proposed under the new pieces of legislation for the common European asylum system. And three, point out what still needs to be done and what possibilities member states have to transpose this new legislation in a fair and effective way. Two of the most salient issues related to claims based on sexual orientation and gender identity have been addressed by the recent Court of Justice, the European judgment I mentioned, which is called X, Y, and Z versus Minister for Immigration and Asylum. Well, the first issue is the so-called discretion requirement, whereby asylum authorities rejected claims from lesbian, gay, and bisexual applicants with the argument that if they went back to their countries and lived their sexuality in a discreet, non-visible way, they would be safe from persecution. Under this argument, the protection afforded by a foreign country would not be justified in their cases. This reasoning was also found in the Fleeing Homophobia study to be used by the asylum authorities of several countries throughout Europe. Although again, diverging practices were prevalent, and some countries have abolished this by case law or policy. Now in the X, Y, and Z case, the CJEU established that national asylum authorities cannot reasonably expect applicants to conceal their sexual orientation or to exercise reserve in the expression thereof in order to avoid persecution. So this represents the end of the so-called discretion requirement in the EU. Now, careful monitoring of the implementation of this ruling, however, is necessary to ensure that it's applied in practice by national authorities. Now, the second question is how asylum authorities should react to the criminalization of homosexual activities and thus of homosexual persons. Again,